was on the first issue of law between Mr. Tanky and me, that is the question of whether dishonesty is necessary in order to make out iniquity. Mr. Tanky relies on the dictum of Lord Justice Gough in the gambling case, which the court has seen. First, the court must in every case be satisfied that what is prima facie proved really is dishonest and not merely disreputable or a failure to maintain good ethical relations. Now I say that that dictum was overturned, and the reason I say that is that there was no argument in Gamlin as to whether dishonesty was required in order for the exception to apply. That was not the plaintiff's case in Gamlin. Rather, the argument proceeded on the assumption that what needed to be shown in order for there to be no privilege in those documents was that the defendants had acted dishonestly and fraudulently.
It proceeded on which assumption?
On an assumption that what needed to be shown in order for there to be no privilege was that the defendants had prima facie acted dishonestly and fraudulently. The issue, in short, was whether on the facts there was a prima facie case of fraud. And for your note, you can see that from the plaintiff's submission at page 5 and the defendant's submission at page 10. And therefore I respectfully agree with the observations of this court in the Kerman case, which you've seen already. And I respectfully submit that the court was right in Kerman to say that the relevant dictum in Gamlin was overturned. The question of whether dishonesty is required. The next authority is Eustace, and in short I say that dishonesty not being required is part of the ratio in Eustace. And it's a Court of Appeal decision and therefore binding. Could your lordships open tab 11 of the authorities bundle, please? And turn to page 1250 in the report.
Which tab is it?
Tab 11. And could I ask the court
Which
to...
paragraph? Which page?
1250.
Yes.
Can I ask the court to read the bottom two paragraphs, please?
Thank you.
So I have 2 points to make about that. It's part of the ratio of the case. This is the court expressly rejecting the submission on which Mr. Morgan, for the defendant, said that the privilege should apply. And the first point is that the court specifically rejected a submission that dishonesty was required. It eschewed use of the word dishonesty as the touchstone for whether the iniquity principle is to apply. And the second point is that in deciding whether the conduct in Eustace was sufficiently serious to prevent privilege, the court said that public policy was the touchstone. And just for completeness, I should take the court to the other part of the ratio in the case, which is at 1252. Letter B. Those submissions were attractively presented, but I reject them. And could I ask
you D.
B for Bertie?
That's a very different approach in looking at the iniquity exception from the approach in looking at whether a claim to legal advice privilege is justified in the first place. I mean, in Derby magistrates, one might have said, well, there's a public policy in maintaining legal advice privilege. There's also public policy in not convicting the innocent, particularly of murder. But the House of Lords said, well, we've struck that balance in favour of legal advice privilege. So it's necessary in your submission that when you are deciding whether the iniquity test is satisfied, that the court adopts a very different approach. I mean, our balances public policy in revealing the information against public policy in maintaining legal advice privilege.
I accept that there is a divergence of approach. Of course, the two issues are different. In Derby magistrates, the issue is whether privilege, once it arises, can be abrogated through some balancing exercise with public policy.
Yeah.
With the iniquity principle, the question is whether privilege arises in the first place.
Yes,
so the first point is there's no inconsistency between the two. I accept it's a difference of approach in asking what public policy should require in the context of the iniquity exception. I wouldn't for myself characterise it as a balancing act when one comes to the iniquity exception. I think a better way of putting it is to say, is the conduct sufficiently serious to constitute iniquity? And in answering that question, one should ask, is the conduct entirely contrary to public policy?
What is entirely contrary to public policy? That's like being a little bit pregnant, isn't it?
Well, some public policies are more important than others. I accept that the test suffers the disadvantage of not being clear. I have to accept that. But it does at least make clear that the bar is set very high.
So that was one of the points that was extremely important in Derby magistrates, that when a person consults his lawyer, he needs to know at that time whether privilege will attach or not. And if it's then left to an evaluative judgment by a master or the employment judge or whoever it happens to be to decide whether or not this is, to use your phrase, sufficiently serious to be entirely contrary to public policy, you won't know when you consult your lawyer what the outcome of that exercise is going to be.
I accept that the test I propose has the disadvantage of not drawing any bright line, but what I would say is simply that it's clear that the bar is set so high that as long as clients remain well below it, they know that they're in safe territory.
One of the problems with Barkers and Eustace is that carrying out the transactions which the Eustaces wanted to do were not actually in contravention of anything. They were transactions that could be undone by the court.
Yes.
But they weren't. At the time they were carried out, they weren't breached of contracts, they weren't torts, they weren't crimes, they weren't anything.
Absolutely.
So, well, I want to ask a question about this important submission you just made. Your submission is you wouldn't describe what is being carried out with the iniquity test as you've described it as a balancing act. You see, what you're doing is you're saying, is the conduct sufficiently serious to constitute iniquity for these purposes?
Absolutely.
And then you ask yourself, in answering that, whether it is entirely, in inverted commas, contrary to public policy. But I mean, it might be said against you on that. Well, this is all kind of semantics, because actually what you're asking is it sufficiently against public policy, the nature of the iniquity, to exclude the principle of legal professional privilege, which itself is based on a whole substratum of reasons. Because when you say entirely contrary to public policy, that can't be right. Entirely contrary, it must be contextual, so it must be sufficiently contrary to public policy to warrant being excluded.
I would gratefully adopt that formulation. Entirely is the language of Mr. Justice Norris in BBGB and
But I don't think that can be right, because what is, my Lord has indicated already, I mean, what does that mean entirely? It's either against public policy or it's not against public policy. And in this context, and it will and that is contextual. It depends on what the context is. And so in this context, what you're saying is, well, there is this principle which is absolute, for all the reasons we know about, and this is iniquitous, but in this context, the nature of the iniquity is such that it should override that particular policy.
Yes.
So it is balancing to that extent, I would suggest. It's weighing up the degree of iniquity which is sufficiently serious.
I would just question what one is weighing it against, though.
But you are having to weigh, because you're having to reach a view about the nature of the iniquity, because I think underlying your description of it, or indeed the iniquity test, is it's not every wrongful act.
I accept that.
It's not every. Some people would say it's iniquitous in their circumstances for somebody to trespass on their land. It's iniquitous. We've made people spend years fighting about that sort of thing. It's the bane of every junior barrister's life, boundary disputes. Maybe you've been spared that. But anyway, so it's all a question of degree. And it's not every tort, it's not every wrongful act. It is something more than that. And you have to work out exactly what it is. You say, I understand this point, you say, well, it's not limited to dishonesty. Fair enough. But if it's not limited to dishonesty, you've then got to work out what it is limited to. And it's something beyond dishonesty, as it were. It's something that's capable of satisfying the test, which is less than dishonesty, but more than an unlawful. It's somewhere in between.
Not necessarily less than dishonesty, just different than dishonesty. I've said in my Scanton argument, dishonesty isn't the only vice. I posit
something other than dishonesty.
Yes.
How's that?
Yes.
It's something other than dishonesty, but more than merely unlawful.
Yes.
Right.
How does one tell where the line is drawn?
I fully accept that the precise location of the line is very difficult to identify on those submissions. And I just fall back on the submission that it is high enough that people can know when they're in safe territory. So, we have examples from the case law of where the line has been drawn in the decided cases. In Crescent Farm, the tort of inducement of breach of contract, conspiracy in that case, essentially interfering with a potential purchaser's first right of refusal over land, was not sufficiently serious. Then we have some of the employment cases, like Gamlin and Walsh Automation, where setting up a business in competition with one's employer was sufficiently serious. So I say it's really a classic example of the common law exploring the boundaries of the law incrementally on the facts that come before it in each case. And I accept that it's somewhat unsatisfactory that doesn't provide one with a bright line distinction between sufficiently iniquitous conduct and insufficiently iniquitous conduct.
In employment law taken as a whole, the question of the employer's true reason for dismissing somebody is just about the most common form of dispute. It arises in unfair dismissal, it arises in any discrimination case where ultimately the employee is dismissed. And it seemed to be saying that if communications between the employer and a legal advisor suggest that the employer's true reason for dismissal was other than the one that is advanced, that privilege is lost, which would mean, would it not, that all such documents are disclosable. That's a very big step, as it seems to me.
Well, that's not quite my submission. On the example you've posited, the iniquity principle wouldn't bite for two reasons. The first is, in the facts as you described them, there was only a suggestion of iniquity, not a strong prima facie case. And the second is that the case law draws this distinction between cases where the lawyer's advice is used in furtherance of iniquity for the purpose of effecting iniquity, on the one hand, and on the other hand, cases where the lawyer is simply advising on legal rights and obligations, even in the context of a client who's behaved in an iniquitous way.
Again, are you saying that to fall within the exception, the lawyer has to be motivated?
No, it's a question of whether the client is using the lawyer in furtherance of iniquity.
Yes, that's what I understood you say before. I think you might have been changing that just now.
I wasn't. The distinction is actually helpfully drawn in one of the earliest cases. It's O'Rourke and Derbyshire. It may be worth looking at it. I wasn't going to take your lordships to it, but it's tab 3.
I think Barclays says it at 152C to E.
It does as well. It appears there too. Yeah. And also, O'Rourke and Derbyshire in fact is quoted at the bottom of 1251 on this point. So just taking up my Lord Justice Bean's question, I mean, applying that distinction in the context of the kind of facts we have before us here, the iniquity principle would not, for example, apply to advice on whether a particular course of action might or might not be victimisation. It wouldn't apply to advice simply on whether or not it would be risky to put someone into a redundancy pool, and whether doing so might expose the client to a claim. It wouldn't apply to advice that the claimant should receive no special treatment on account of his protected act, and that he should not be immune from inclusion in the redundancy pool. And it wouldn't apply to advice on how to defend.
Sorry, it wouldn't apply to seeking advice whether the employee should be entitled to special treatment.
Yes. It wouldn't apply to advice on how to defend a claim of victimisation. And all of those propositions hold good even where the client has apparently acted in an iniquitous way, because the lawyer's advice is not being used to facilitate that iniquity. And that's the O'Rourke and Derbyshire distinction. So I was just going to show your lordships the other part of the ratio in Eustace, and that's at 1252B. So had you read that already? I can't remember. I think I mentioned it, but didn't give you a chance to read it.
125.
So 1252B.
You just mentioned that.
They've read it, thank you.
So Lord Justice Sheeman does adopt the test of sufficiently iniquitous for public policy to require the communications to be disclosable. At the bottom of the page he says the balance of advantage is in permitting inspection.
Yes, at the bottom of the page it's unclear to me at least whether he's exercising some kind of discretion once the iniquity principle does apply to all of disclosure. But I do place great reliance on the other passage just quoted. Sufficiently iniquitous for public policy to require.
Yes.
So that, I say, is part of the ratio of a Court of Appeal decision. Mr. Tankey's submission yesterday afternoon, I think, was that if that is the ratio of Eustace, then it's been overruled by Derby magistrates. And I say that's incorrect for reasons that we've canvassed already. The decision in Derby magistrates was that if privilege arises, once it arises, then it cannot be lost through a balancing exercise with the public interest. And we can see that in Derby magistrates, which is tab 12. At the conclusion of Lord Taylor's speech at page 508, right at the bottom of the page, last two lines. For this reason, I am of the opinion that no exception should be allowed to the absolute nature of legal professional privilege once established. And the point about the iniquity principle is that it prevents privilege from arising in the first place. And the theoretical basis for that is twofold. First, confidence is a necessary ingredient of privilege, and non-confidential communications with one's lawyer are not privileged, and there's no confidence in iniquity. So one of the essential ingredients of privilege is missing in the first place. And I think the second theoretical basis for that is that privilege applies only to legal advice from one's lawyer in the course of his professional engagement. But advice in furtherance of iniquity is not legal advice in the proper course of a lawyer's professional engagement. It's an abuse.
Could you repeat that again? Advice?
Privilege arises.
No, you said advice. I think you said advice in pursuance of iniquity is not in the ordinary course of the solicitor's
Professional engagement.
Why do you, from whose perspective, from the point of the solicitor, whose motive may be completely, you may get the law wrong, or get it right for that matter, doesn't really matter, and who may not be aware of the intentions of the employer. Why is that not in the ordinary course of the solicitor's duty?
It's an abuse. This is what JSC in particular discusses. It's an abuse of the lawyer-client relationship for the lawyer to be used as a tool to effect iniquity. So anyway, I'm possibly getting away from the point which I'm trying to make, which is that if the iniquity principle applies, privilege never arises in the first place, and therefore there is no inconsistency, or rather I should say Derby Magistrates has not overruled the decision in Eustace, because they're about different issues. There's just one further reference I should take your lordships to on the issue of whether conduct is sufficiently iniquitous for the principle to bite. That's JSC, tab 24,
Please, thank you.
paragraph 68 at page 283. Could your lordships read 68, please?
Yes.
It's a much less important case than Eustace. It's first instance, and I wouldn't wholly adopt the formulation there, but Mr. Justice Popplewell nonetheless said the principle extends to other equivalent. Principle is not confined to criminal cases, but extends to fraud or other equivalent underhand conduct which is in breach of a duty of good faith or contrary to public policy.
So you would leave out the words or the interest of justice.
Sorry, I didn't read that far. Or the interests of justice.
You-
Contrary to public policy is probably putting the test too low.
Right.
Sufficiently contrary to public policy would be a better formulation. And that's closer to what we see in Eustace. And I also say that test which I proposed is entirely consistent with the underlying public policy considerations behind the doctrine of privilege, because there's no public interest in clients using their lawyers to effect iniquity. So just applying the test I've proposed to the facts of this case, I simply remind your lordships of what I said at paragraph 27 of my skeleton argument. Sorry, I have the wrong reference there. Paragraph 59.
Paragraph 59
59, yes.
of your skeleton.
Yes.
Yes.
And that's why I say the conduct in this case, as a matter of fact and degree, reached the high threshold for sufficiently serious conduct.
Well, that's agreed. That's agreed. Mr. Thankey agrees that if the email shows that Shah was using redundancy as a cloak for legal reasons, then it's within the exception.
That's right. Should your lordships find that the intermediate interpretation of the email is the right one, and that there was no element of a cloak here, there was no deception in the advice, but it was nonetheless advice in furtherance of victimising and discriminating against Mr. Curless, then I would say that for the other reasons set out in paragraph 59, this is still conduct which is sufficiently serious to be sufficiently contrary to public policy. On the second...
Sorry, Mr. Handler, before we leave paragraph 59, you draw attention to the fact that Mr. Curless had been employed for 27 years. But could the resolution at this point be any different if he'd only been employed for 27 weeks?
I say that does make a difference. If someone loses a very long-standing job which has been part of their life for a long time, which has been their livelihood, and they're left on the employment market in their 50s, then that is an aggravating feature. The second legal issue between us, I've reflected on this, it's the strong prima facie case versus very strong prima facie case issue. You have my submissions at paragraph 64 to 69 of my skeleton, and I don't propose to add to those. And there was only one other point I wanted to deal with before I sit down, and that was...
Is there any other area of the law where there has been some jurisprudential elaboration or explanation of that difference? Has some court directly confronted the difference between prima facie and strong prima facie?
Not that I'm aware of.
There are three gradations, normally speaking, between one extreme end. At one end, it is something which is more than trivial. At the other end, it is something which is more than which is probable. These are the kind of two ends of a range. What I'm unclear about, and that's why I would like to have some help with authority, but I don't really want to get into this because otherwise it'll be quite a long time longer. It may be necessary. I'm just asking you this question because you're going for this strong prima facie. So prima facie would normally mean, I would have thought, certainly something is more than trivial, and certainly less than probable. It doesn't have to be as high as probable. It might have to be, depending on the circumstances, it might have to be more than a serious issue. It might or might not. That's quite a difficult issue. What I'm not clear about, and I think you're saying there's no authority on this point, is where on that line, and how do you decide where it is on that line, the difference between prima facie and strong prima facie. That's what I find very difficult conceptually to understand. It's not just on the facts. I find conceptually very difficult to understand.
So do I. And that's part of the reason I say it's a sterile distinction. So one point which I have addressed in writing, which casts some light on this point but doesn't directly answer your Lordship's question, is that in Weldon number 7, the court said that it wasn't necessary to satisfy the court on the balance of probabilities.
Well, that's clear.
So, yeah.
I mean, prima facie is undoubtedly, there's no question about that. As I said, it's quite clear it's more than trivial. It's quite clear it's less than probable. But in the difficult enough as it is to find out what prima facie means, to find out what... Anyway, there we are. We haven't, to be fair, we haven't asked Mr. Thankey to go into that, so I think probably that we should leave it there.
There was just one other point I wanted to do with. Your Lordship asked yesterday about the practice in the employment tribunals and the EAT when it comes
Yes,
to privacy and hearings.
Yes, about anonymity.
About anonymity,
Yes,
yeah.
I'd like to hear what you want to say about that.
I wasn't going to develop the point much in writing, but I think the short answer, orally, sorry, I think the short answer is that there is a specific statutory jurisdiction for the tribunal and the EAT.
What is that?
Well, I was going to hand up an extract from a textbook which covers the point. I'm afraid I haven't really prepared oral submissions on it, and I don't want to get it wrong.
No.
So if I could hand that up.
Has Mr. Thankey seen this?
Yes, yeah.
I have, and Mr. Halliday described the principle to me very succinctly, if I can put it that way.
Yes, I mean, the point is that statutory jurisdiction is specific. It includes, for example, a specific jurisdiction which applies in cases of sexual misconduct, but the discretion to exercise that jurisdiction should be exercised in accordance with the general case law on the open justice principle.
So this is an IDS employment law handbook. Is that what this is?
It is, yes.
I mean, has it got a particular name, this book?
It's the IDS employment law handbook, and this particular volume is called Practice and Procedure.
Volume 5, Employment Tribunal Practice and Procedure. Right. Do we have to read all of this?
Yeah.
Well, Rule 50, which is referred to on the third page, this sounds very similar to the relevant provision of the CPR.
All right. You don't want to make any further submissions on that?
Yes, that's right.
Okay. Anything further?
Nothing further.
I think we're going to rise for a minute just to see how we take the rest of this case.
Silence, court trials.
Mr. Halliday, we are extremely grateful for your submissions, both written and oral, but we've come to the clear conclusion that the email in question is privilege, is not within the exception. And for that reason, we don't feel we need to call Mr. Thankey, Mr. Thankey further to deal either with the law or the interpretation of the email. And because you're relying upon the pub conversation simply in relation to the interpretation of the email, again, we don't feel we need to call upon him to deal with that issue. And similarly, the issue of prima facie or strong prima facie does not seem to us, again, to need a reply on that point, although we mentioned it very briefly. So, unless anybody wishes to protest, we will now simply adjourn to give our written judgments and our reasons in those judgments. And in the course of that, we will deal with the question of anonymity. And so far as the further material is concerned, we will deal with those as well at the same stage. Thank you very much. Mr. Thank you. Anything you want to say?
Yes, just one matter. In terms of your Lordship's judgment, you asked about authorities in relation to prima facie case, and I did actually show you a passage, but just to remind your Lordship, in O'Rourke and Derbyshire, there was a reference to a strong probability that there was fraud.
Yes, yes.
It's at page 633 of O'Rourke.
Yes, thank you very much. We're both grateful to both counsel for their submissions. We will reserve our judgment for the reasons I've given, and we will turn those down as soon as practicable.